Okay, this is Red Cedar Flats LLC versus Sears Roebuck and Company et al. Docket number 19-741CB. And this is the time set for hearing on some of the defendants' motion to compel and to adjourn dates. And could I first have your appearances for the record, please?
Thomas Eckhart on behalf of plaintiff.
Candace Phoenix on behalf of all of the et al. Defendants.
Yeah.
And Maggie Mason on behalf of Sears and Roebuck, the only non-et al. defendant.
All right, then Ms. Phoenix, this is your motion on behalf of the et al. Defendants. Go ahead.
Thank you, Your Honor. Yeah, we sent a request to produce to counsel for plaintiff back in April of 2020 when discovery was still open for written discovery, and we did not receive a response to that. We have noticed that in plaintiff's response, there was not an indication or an explanation as to why that first set of discovery wasn't the first set, but why that second request to produce was not answered. We did know in the response that there was a reference to this third set and how that was outside of the written discovery window. However, we wanted the court to note that as parties in this litigation, there's been several written discovery packets exchanged between plaintiff and co-defendant beyond that April 30th date. I did note that in May of this year, plaintiff was sending answers to co-defendant second Roggs. Also in June of this year, there was discovery sent by co-defendant to both of us, to us and to plaintiff, which were answered. And there was no response then that these were outside of the April 30th window. And so for all intents and purposes, similarly with holding the deposition before the facilitation, the parties have agreed sort of as using the later deadline in August as the discovery deadline for all discovery. With that being said, Your Honor, there was also information that was obtained at the deposition of Mr. Chappelle, which gave rise to this third request to produce. There were specific times throughout the transcript where Mr. Chappelle would respond by saying, you know, you're going to have to send me this in writing. I don't really know all this information. You're going to have to send it to me in writing. And so there was an email sent by counsel for co-defendant Sears with a list of items, and I chose to do mine in a formal request to produce so as not to run into a situation where, you know, they say, well, it was informal, you didn't really make a formal request. And essentially they did send some documents in response to co-defendant Sears, most of which I don't think actually answered or provided the document she was asking for. And so in my request to produce, I simply explained why they had not actually given the document she requested and re-requested those, as well as requested the other documents that I noted in the deposition that were referenced. So I do believe that the dates in this case could be adjourned to assist the parties in being able to finish up and button up all these different discovery requests. And as to I guess the idea, if the court is at all inclined not to allow the discovery, there really is no excuse for not responding to the first or the second request to produce. And I will add, Your Honor, that, you know, these discovery requests are continuing. So, I mean, had they actually attached documents to their initial disclosures, which I don't see any documents attached there, and had they actually responded to my second request to produce, some of these things would have been known or dealt with way before the deposition of Mr. Chappelle. And we could have worked those out a little bit earlier. So, you know, if the court is at all inclined not to grant the motion to compel the discovery, then I would ask that the court consider not not permitting plaintiff to produce those documents later. I'm worried that on behalf of my clients, if I file a motion in this case, then in response, I'm going to see a bunch of documents that were never produced to me throughout discovery. And I would ask that the court not permit that to happen. Lastly, in response to our motion, counsel for plaintiff mentioned that we, had requested the depositions of Ron Calhoun and Dan Poxon, and he indicated that, well, there's really no good reason that you should need those now. There were several times throughout the deposition that Mr. Chappelle specifically says, well, I don't know that Ron or Dan would know that. It was my understanding that Mr. Chappelle was going to be able to speak to the issues in this case, which is why we noticed his deposition. And as a matter of fact, at the outset of the deposition, he was very much confident that he would be able to answer all of my questions and that we wouldn't need to secure depositions from other persons. But as the deposition continued, and I don't know if it was fatigue or what have you, but he started to say, well, I don't know that, Dan will know that, Ron will know that. So in light of that, Your Honor, I do believe it would be appropriate to allow us to take those depositions. And I don't believe that, facilitation of the case is going to be as fruitful prior to receiving those depositions and getting these discovery answers from plaintiff.
All right, thank you. Mr. Eckhart?
Your Honor, first I'd like to mention that we've responded to, in total, 76 discovery requests, interrogatories, and requests for production of documents. We produced hundreds of documents. I think this is a pattern of delay on behalf of the defendant in this case. Your order provided that written discovery would be complete on 30. And to me, complete means that it's completely resolved. The second request that is referred to us on April 30th. So obviously we didn't have time on the same day to respond. Nevertheless, we have responded to the discovery. The documents that were requested, there was only one new document to be included in our complete response. The defendants already had those documents, and that's attached to our package of papers. And we sent their response on August 26th. Now, mediation was to be conducted by June 12th. The defendants requested that they get the deposition of Mr. Chappelle. They never requested anyone else's deposition. And we agreed that we would do the deposition for the benefit, hopefully, of all before we did the mediation. So Mr. Chappelle's deposition was scheduled on the 3rd of August. It was conducted. Mediation was scheduled on 8/31. I didn't agree to a postponement of mediation. I expected it would go forward before we got this motion. With regard to the third set of requests, they're redundant, seeking irrelevant documents. They were served on August 13th. The discovery cutoff was on August 14th. So in the case of sending us discovery very late in the game. In terms of the depositions of Mr. Poxon and Mr. Calhoun, the defendants have been well aware of Mr. Poxon and Mr. Calhoun. Mr. Poxon was disclosed on January 17th as a witness. The nature of his testimony was disclosed on February 5th. Mr. Calhoun was disclosed on May 1st. The nature of testimony was disclosed on May 1st. No request was made until the end of discovery. So they could have deposed those two individuals at any time. It wasn't a prerequisite or dependent on what Mr. Chappelle testified to. They knew about these witnesses. They knew they were eyewitnesses. A little late in the game now to try to pull them in. So for those reasons, we request that the motion be denied and that we move forward.
All right, and Ms. Mason, I didn't have anything from you, but did you wish to be heard?
Yes, Your Honor, just a moment, if you may. I have to say, Ms. Phoenix and I have attempted to get information from plaintiff repeatedly on some issues, and we have been having some difficulty. I've had to ask for discovery more than once that I felt was is relevant and responsive to my request. Most importantly, we still do not have explanation for the amounts of rents that plaintiff is claiming to have lost, which is the vast amount of damages at this point. So I do believe, Your Honor, that we may need to conduct additional discovery once we do get that information, which we still don't have. And as Ms. Phoenix indicated, the importance of Mr. Paxson and Mr. Calhoun's testimony was not made obvious until the deposition in August. So I believe that Ms. Phoenix is bringing this motion very correctly, and I concur with her request of the court.
All right, thank you. And then Ms. Phoenix, did you just want to add any rebuttal remarks quickly?
Just one little thing, and that is that I thought I heard in response that Mr. Eckert said that he supplied answers to the April discovery on August 26th, and I've poured through my email here and I don't see that, and I've also poured through our electronic file and I simply don't have that.
Right,
Well,
he said that in his response. He said he served the responses on August 26th, Exhibit E. Correct, Mr. Eckhart?
That's correct. And I mailed those myself. I know they went out.
Mail, that's the problem.
Okay, they were mailed. Okay, it's possible I just don't have them yet.
But certainly counsel have, Your Honor, because they're attached to our motion, which I've served on 2 different locations for Ms. Phoenix, by email, by mail, and also I sent a courtesy copy directly to her by email last week.
Yeah, and I'm in that.
That's not a mystery.
Okay, yeah, the answers to the April 30 interrogatories are attached to the plaintiff's response as Exhibit E, and I'm satisfied that based on the attachment that has been answered. I'm surprised that no one mentioned this, but under the discovery rules that took effect on January 1st, when it says discovery has to be completed by a certain date, it means that it has to be answered by that date. So you can't send interrogatories, I'm speaking from memory, but I think I'm right. You can't send interrogatories on the last day of discovery. You have to send them before that in order to meet the deadline. So the April 30 interrogatories that have now been answered were actually not timely because written discovery was to be concluded by April 30th. So in any event, they have been answered. And then the August 13 third request for production of documents were also not timely, and those have not been responded to, but they were not timely because all other discovery was to end on August 14, the very next day. And furthermore, the plaintiff has set forth in the plaintiff's response why those requests for production are, again, slightly different standard than what the plaintiff says in the brief under the new discovery rules, but they're basically not relevant to a defense in this case, which is the standard under the changed rules. And the depositions that the defendants are indicating they also need would be the deposition of Dan Paxson. Well, Mr. Chappelle may have referred to Mr. Paxson as Dan would know during his deposition, but the plaintiff disclosed Dan Paxson as a witness in February. And if I recall, this has something to do with a leaking refrigerator or refrigerators, and the information disclosed was that Mr. Paxson witnessed water surging from underneath a refrigerator on May 28th, located the unplugged hose and turned off the water supply. So not only did the plaintiff disclosed Mr. Paxson in February, but his knowledge of important facts in this case would be very evident from that disclosure. And as regards Mr. Calhoun, he was similarly disclosed on May 1st as a witness in this case. I would usually freely grant extensions of dates, but there has to be a showing of good cause. And I have not heard any good cause for the extension of discovery. And I am going to deny the defendant's motion to compel and to adjourn the dates. And I'm going with the plaintiff's request that the plaintiff is not compelled to respond to the third request for production, but those documents likewise won't be used in this case. And additional depositions will not be taken, and facilitative mediation that we had previously scheduled and discussed will take place within 15 days, more or less according to the mediator's schedule. Does someone want to send in an order that reflects that?
I
I
can
could do
circulate
so.
one. Okay, that's fine, time either
I
way.
can do so, yeah.
Okay.
All right. Okay, thank you.
Thank
And
you,
if
Your
there's
Honor.
nothing-
Thank
okay,
you very much.
That'll conclude the hearing.